let's get started. I'm going to screen share again. Lol, shut the fuck up. Alright. So, today we're going to talk about the judicial legislation as well as the duties of the lawyers and the lawyers and the judexes. I'm going to start with I will teach you this. This is partially some things that I learned before I became a judicial, but partially also things I learned from my experience within judicial college. I can teach you certain things, but a lot of things will still come with experience. So when you do become a lawyer, I recommend you fight for your place and you take every opportunity you can to present a case because that's how you really will learn how to get better at being an advocate. However, I'm going to teach you the basics of being a lawyer because that's as far as anyone can teach you how to be a lawyer. The rest comes really down to yourself gaining experience. All right, let's get into it. Let me switch to my whiteboard. Um, Actually, I'm not sure I'm going to. Okay, anyways. Okay, I'm not going to. First of all, lawyers. Lawyers have the duty to represent their client in a court trial, but not the other way around. Lawyers can never forget that their client is the king, basically. Okay. They listen to their clients. Like, his client determines whether you plead guilty or not guilty. So unless your client gives you POA, power of attorney, POA, they determine whether or not you plead guilty, and you cannot change that on your own. If you do not want to do this, you have to leave the case basically, but that's never done because that would be it's Roblox Rome. That would be just there's no honor that you're losing by not taking the case. Anyways, that's the basic. That's something you always have to remember. You serve your client, not yourself. However, you can advise. You must advise him in cases where it's obviously not going to work by pleading guilty. So you must advise him the right thing, and you will know when it's good to plead guilty and when not to plead guilty. This is for the defense. When it comes to the prosecution, when it comes to prosecution, your client decides whether or not you drop the charges. That's pretty straightforward. I take it I don't have to explain. Like, defense is the party on a case that is being prosecuted, and the prosecution is the one that prosecutes. So the prosecutor is the plaintiff, also known, and the prosecution will always be putting charges upon the defendant, and so on. Where can you find this? Very important. I'm going to switch to the index of legislation right now. How do you do this? Oh yeah, here. All right. Okay. Yeah, this is the Constitution. So as we were talking about judicial legislation today, you can see that there's 4 ordinatio judicalis. They're basically the basis of our judicial system. In the first, you're going to find all of this. The foundation declaration, this you really need to know. This is basic rights, basic procedure that counts for everything. Absolutely read it. And then there's the description of the courts, what every court does. And then there's the duties I'm talking about right now, about the judex and the avocati. Now, as I just said, the avocator's duty is pretty clear. You represent your client, he tells you what to do, unless they grant you power of attorney. If they do that, if they grant you power of attorney, it means that they grant you the power to represent them to the fullest extent. You become them basically in the case. You can decide whether or not you plead guilty or whether or not you drop the charges. That will happen. That's what happens when you receive POA from your client. When will this happen? When your client A is not interested, or B cannot attend the trial and is willing and is trusting you to take his best interest at heart. Mainly, that is something you have to keep watching for. That you represent the best interests of your clients, because otherwise your client will be very mad at you, and that's something you basically don't want, as you have a reputation to uphold within Rome. All right. So, oh yeah, something else. Let me go back to my whiteboard. A second duty of a lawyer is to interpret the law. You see, not only the judge interprets the law. You see, the law has not one meaning. There's always possible interpretations of the law, and you will have to convince the judge of a certain interpretation. Now, the advocatus interprets the law, meaning if you're in a court case, you will want to interpret the law, and you will use that interpretation to win your court case. Basically, the judge might just take your arguments if they are strong enough. So basically, I'm going to talk about case preparation. Yeah, I'm going to do that afterwards. I have one thing to add to lawyer. I will switch back my screen again. This is getting annoying, but it's quite important. A couple of things you have to be aware of as lawyer is, for example, collusion. If you've seen Netflix series like Suits, you will know what it consists of. But anyways, you can find it here in the fourth part. So collusion is basically when your advocate is on one side, your defense, and you make an agreement or something with the with the other side, so with the prosecution, against the best interests of your client. Like you have plea deals and then you have collusion. The plea deal is where you both come to an agreement regarding the plea. For example, you both decide to drop the charges in exchange for something else. That's a plea deal. By the way, that is something. No, a plea deal. Okay, a plea deal happens during a trial. But what I'm trying to say is you can make a settlement. And that basically is something you do when you realize that there is no winning in the case. You will not be able to win. So something you will try to do before the case is try and find something both parties can agree on, so that there doesn't have to be a trial, no criminalization. For example, something that happened today is so one party chases another, and then the other party countersues because of something else, and now they will both decide to drop the charges and act as if nothing happened. That's a win-win instead of a lose-lose situation. All right. A plea deal is when you, at the end of the trial, instead of letting the judge decide the punishment, You're going to agree with the other party what the punishment should be after the judge declares guilty or not guilty. Anyways, that put aside, conclusion is the opposite of making a plea deal. It's basically one lawyer making a deal with the other lawyer against the back of his client, which is not good. So beware of it. Something else you must be aware of, and your clients may in the future drag you into this shit. It's called, it's in torts, malicious prosecution. So basically, suing someone without having grounds. You need to be aware of that. Sometimes your clients they're not always as judicially educated as you will be, and sometimes they might not see that the evidence they provide is not related to the case you are is not related to the charges you're dropping, and that would be grounds for malicious prosecution. So that opens you back up to a countersue, which can be which can prove in your disadvantage. And then there's also abuse of process, is if, like for example, word gets out that you and your client are suing someone in order to get them removed from their position and not because you feel unrightfully treated. Well, that's abuse of process because you're doing it for the wrong reasons. So also beware of the real intentions of your client. All right. Now, when it comes to the judges, it gets way more interesting. So as you can see in the first part, I'm not going to keep this open. You can just now you know where it is, where you can find it. I'm going to change back to my whiteboard. All right. Okay. A judge has the following characteristics: he is independent, and is impartial. Those two things are absolutely fundamentally important. These two constitute the entire thing that of the judicial college. If this doesn't exist, there's no point in having a judicial college. What do I mean with independence? The judge cannot be influenced by exterior. I'm going to give you an example of something that happened today also. The Caper Judex expressed his opinion in the comments of a case card, which he was not even presiding over, but still. By doing this, like the Caper Judex is a major influence over the other Judexes because they follow his lead. He's considered a good judicial authority. So automatically other judges are going to follow him, and basically that harms both the independence and the impartialness, because the judge that presides will be influenced by the Caper Judex, touching his independence in the case, because the Caper Judex already made up his mind. He let his opinion known even before the case started. And in this case, he said something about the evidence being bullshit and all that. Well, that plays in the disadvantage of me, the defense, because the prosecution will now be able to say that the judge has already made up his mind because of the Caper Judex and stuff like that. Okay, I'm going way too far now. I'm not sure you're still following me. But these two things are really they're really fundamental for the judicial college. All right. Something really important about independence is reasonably the judge decide his verdict on his own. There is no exterior influence. The judge does take arguments from the parties, and not this wall in your ears. Remember this. The Judex takes on arguments. He listens to arguments that the parties bring forward. Furthermore, he can only use arguments that have been said in the case. He cannot invent his own arguments. He can only use what the avocati have brought forward. But nonetheless, his verdict remains independent. He makes it himself. He chooses it completely. He does not have to follow either party in his verdict, all right? The verdict, by the way, is the case decision. And there is one exception to this everything that I've said about the judge only being able to take on arguments that the party said, and that is the Constitution. When you go to the Ordinatio Judicalis, the first thing you're going to encounter is the Judicial College upholds the Constitution at all times above all else. What does that mean? When you are a judex and you were in a court case and you notice that that the parties are arguing, but they forget to mention a clause in the Constitution, they forget to apply it, they forget about it, then as a judge, it is your job to bring it forward, to notify the parties of this argument, and you will imply it for whatever party, for probably defense or the prosecution. You're going to imply it in your reasoning, because that's your constitutional job, because of this clause in the Ordinatio Judicalis. I had to do it last week still, about conflicting. I will go over that after in a while. Anyways. Okay. So that's about the roles of a judex. Alright. Then, something else, and now that we're also busy about the Ordinatio Judicalis, one important thing about the second part is judicial precedent. I'm going to switch to my Google Chrome again, because this is quite important. Something you cannot forget. You can see here some rules about precedent. I've changed them a lot. Some people have changed them a lot. It's evolved quickly because precedent is important. I'll tell you the role of precedents. Precedent fills up holes in the law. It closes gaps. It closes interpretations. Like, for example, when a law is to be interpreted too wide, the precedent can temper it. Precedents can also fill up additions. You see, it fills up the gaps, and you can find it on the Judicial College Board. It's really important that you check this before a case, that you know this. There is, on one side, there is the guidelines. These are literally the things that fill up the law. And these are sentences that say how long you will be criminalized for a certain infraction. Now, these are also up to changes. If you read this in the Ordinatio Judicalis, it says, there was something. Anyways, no, I'm mistaken. Okay, no, okay, and never mind. So yeah, so that's the role of precedent, and it's right here, and you should read it. It's not long to read, but you need to know these things. Some of them are really important, about like this one. Also this one. Oh yeah, that's actually something I wanted to say. You cannot sue someone for breaking the Constitution directly. You cannot sue someone. You cannot put up a case card and say, oh, this person, he broke Article 4 of the Constitution. You cannot do that. And it's reasonable. What you can do, what you're supposed to do, is go to torts. Wait, I'm running ahead of my... Anyway, I'll leave that for later, actually. I'm going to do this structured. I'm sorry, my mind is running all things mixed up, you know. Okay, I'm not going... Alright, anyways. Alright, let's continue. A last thing you really have to know is in the fourth part is excuse me. Wait. Yeah, conflict of interest. This is something you will have to use every case. As a judex, you will have to check if you yourself are not in conflict of interest with with the parties. For example, this is the most important one about all this. Having a noticeably positive or negative relationship with another party in the case. This looks certainly like a very vague description. I will give you an example so that you can make it clear in your own head. For example, you are in the same gens. Or for example, you and the defense are in the same legion. Like that. You have to think about it like that. You're close to each other, so you have to have a friendship. For example, yeah, actually being friends as senators, for having the same pattern. Like, okay, senators can preside over each other's cases. That's precedent, but it works like that. Okay, I think it's clear now. All right, that's it for the Ordinatio Judicalis. You absolutely have to read them because they're foundation of our judicial system. So I really recommend it. At least go through them once before you actually become a lawyer. It will help you definitely. All right. Next thing is trial procedure. Sounds absolutely boring, I know, but it is absolutely important. Because if you're a lawyer and you don't know what to do or how things happen, you will be there as a total retard and you will be yelled upon by the other party and by the judge. And that's something you absolutely want to avoid. Before we go into that, there's something important I have to say about the case filing. Alright? So case filing happens through a bot in the judicial college and it comes here and stuff. What I have seen by judges multiple times in the past is someone files a case and they put in evidence and the judge puts in the comments, denied, the evidence does not prove a thing. Ladies and gentlemen, if I ever see any of you do that, I will come down there, I will slap you in the face. Yeah, thank you. Well, you can. Okay. All right. I will explain why. The trial is supposed to determine. That's what the trial is for, to determine if the evidence actually is related to the case. See, if you deny a case based on that, there's no point in having cases at all. So don't do that. You can deny the case if any of these are missing. All right? If it's filed incorrectly. But as soon as there is evidence, you are supposed to have a case. Rest assured, if the evidence is absolute bullshit, your trial will not last longer than 15 minutes. All right? No, actually, it will not last more than 5 minutes because you will invite them into the server. The other party will say, a motion to dismiss this evidence, and then it will be gone and your trial will be over because if there is no other proof. But it's not a grounds to deny the case from happening at all. Why? It's very important. Why? Because the parties can still introduce new evidence to support the evidence that seems sketchy. You're supposed to argue about it. You're supposed to, they can bring in additional witnesses to support the evidence and stuff like that. So never ever deny a case because because you think the evidence does not prove anything. All right. Okay, now that we've moved out of that, this is not. Well, you have to. I'll just read this once, but it's not really important from your day-to-day thing. All right. Moving on. I'm going to go back to my blackboard. Actually, I'm going to stay here. Doesn't matter. Pre-trial procedures pretty straightforward. I'm going to run through this really, really quickly, really the basics, so that you understand everything. So the pre-trial is. I'm not going to read this. It's very simple. All right. So the judge invites you. You agree on a date. time, and whether or not your trial would be a bench trial, which is basically the parties and the judge, or a trial by jury. And then there's a jury of 5 people at least who will decide upon your verdict. Now, the question on when it is smart to ask for a trial by jury, I cannot answer. Sometimes, sometimes you might think that a jury can be retarded, that they're easier to convince than a judge who is basically schooled in everything. But at the end of the day, even your jury members will check out what you say. They will hear the arguments that the other party is making. And it might even turn out in disadvantage because they do not know the specifics of the law, and while the judge is more qualified for it. So basically, I try to avoid trial by jury because, the judicial specifics. Yeah. So that's really administrative. This stuff. The pre-trial is what happens before the trial. So that's all the administrative arrangements. So then, in the trial, the first thing that will happen is the judge will see if all parties are present, blah, 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 open the court. And then he will ask the defendant, do you plead guilty or not guilty? The defendant will say guilty or not guilty. If he says guilty, then he will move on straight to the sentencing. He will make his decision in front. He will say, okay, the person says so many days. Okay, so many days, court concluded. 5 minutes, no more. All right. If he's not guilty, he's going to allow the prosecution. He's going to allow the prosecution to begin their opening statements. Okay. What is an opening statement? An opening statement is an introduction to what's about to happen. All right. I'm going to show you one of the an example of a case preparation that I made some time ago. Let me get it. I saved all my documentation from every case, like every preparation. This here looks like a pretty decent preparation. Yeah, exactly. All right. I'm going to change my screen again. All right. Here it is. All right, you can see that, right? So what I do is I put down all the charges. All right, you can see attempted murder and attempted murder, and then all the proof I have, and then Romani Fidem, all the proof I have, slander, all the proof I have. And here, because the proof was quite lackey, the proof it didn't speak for itself, I put down some additional argumentation, you see, to help myself remind the reasoning that I made while preparing. This is really important because you don't want to be in court thinking about why again you put this in, you know. So this kind of preparation is really good, I think, because for all clarity, you will have to, during the trial, the judge will always ask you to put the proof that you are discussing. He will ask you to post it in the Discord. Well, you don't want to keep the people waiting because they will just get frustrated. So it's important if you have a lot of proof to organize it like this. All right. I'm going to go back to blah blah blah. Okay, there we go. All right. So that's what will happen. Opening statement. I used to prepare that too in the past. Now I only do it for really important cases, for cases in which there's a jury that I need to convince. Nowadays I just blabble something because it doesn't really matter. You're just introducing stuff. You're giving a first impression too. So as a storytelling lawyer, it's good to prepare it. Don't make it too long. Like, very important. In the opening statement, you don't bring forward any proof. You just say, oh, we are here today because blah, 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 murder, blah, 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 or because that did not happen, my client is not guilty, blah, 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 all right? No proof whatsoever. You just keep a short introduction, no more. And then you continue. Then the defense will give opening statement. Then the prosecution will be able to bring forward the actual case, the actual proof, the actual arguments. That's where the debate happens. You argue, like the prosecution brings forward proof. They say blah blah blah. He murdered this person. Here's the evidence. Then the defense may object. They may say objection. And then this is where the list of objections comes in. You see, there's a law on motions and objections. This is something that every lawyer always keeps open during the trial. Like before you go into trial, you open this in the background. You scroll down to legal objections, and this you keep open on your screen for when you need it, because you will need it. You say objection, but you cannot say objection. I do not agree with that statement, because the judge will shut you up. You have to use one of these always. So you have to read. I recommend you at heart to read all of these and know what they stand for. See, the most used is the widest used is assumes fact not evidence. I call this objection bullshit. All right, it's when the other party says something that does not hold up. It's either not in evidence or it's not in the law, or just like that. So basically, when the other party is lying or is spreading bullshit, it's something I have to use against Sark a lot of times, because he doesn't do anything else. Yeah, all right, and the others you have to note too, because these can make your opponent shut up. It's certainly important when you're interrogating someone, when you're having a testimony in the court, when someone is testifying and asking questions, and you gotta protect them as much as possible with these objections. All right, this is where the real judicial fireworks come in. This is the real battle, the objections. That's really all right. I'm getting horny over them. All right, anyways, let's continue. So yeah, as I said, back to trial procedures. So after the main arguments and debates are closed, there will be a closing statement. The closing statement, I recommend you prepare it. Why? Because it literally is the last word you get to say to the judge before he makes his decision. So basically what you do in the concluding statement is you summarize all of your arguments and you present them as one package to the judge, like one structured package of your arguments. You deliver it to the judge in a structured way, in a way that is strongly convinced. Make sure you write it and you rewrite it until it sounds exactly right. That's what you do with the closing statement. And then the judge will call a recess, make his decision, blah, blah, blah. All right. God, we've been going on for 32 minutes. This is getting rather long. However, I want to pull this through because this is basically everything you have to know. You can watch it in several things, All right. Moving on. We have gone through that. I expect you to read it again, although you now know the basic lines of how it happens. Something that is really important for judicial usage comes now. Yeah. Lex omnes tortis. I mentioned something about the Constitution earlier, that you cannot sue people for the Constitution. Now, that is true. You cannot, just remember that. You cannot file a case and say, oh, this person broke the civil rights. You cannot do that. What you can do is go into torts and use one of these. All right. For example, when when a judge breaks the civil rights thing, when he doesn't keep it up, you go to incompetency. Incompetency is someone you get to use a lot. You see, and then you will apply this, and you will link it to the constitutional rule. That's what you do. That's what these torts serve for. You've got laws, and then if they break a law, you can both, if it's just a law, you can, for example, ordinatio militum. A legate lankrocks someone illegally. All right, take that example. When you put up a case, you will not only put up as the charges. You will not only put up lex militum, you will also put up things like harassment if it's happening over long term, or things like incompetency, as we just said, and so on. You see. Uh, so that's not okay. First, I'm jumping the rope right now. I'm feeling like I'm losing you. Anyways, I should go over what is a tort. A tort is a wrongful act or an infringement of a legal rule leading to a legal liability. That's the description of a tort. So despite of the name Ordinatio omnes tortes, which means all of the torts, this does not contain all of the torts. All right, where do you think are more torts? This is when I tell you this is not all of the torts. Where could the other torts be? I'm going to tell you because I'm not going to wait like those shit as teachers of yours in high school that wait for someone to pathetically answer. No, like simplest, also torts. Murder, that's a tort. It's not called a tort, but it is a tort in fact. Attempted murder, so on. All of this bullshit. So this is all torts too. Okay. So yeah, when you file a case for someone, when they ask you to do so, do not only think about the actual law they're breaking, do also think about torts, because the more torts you can add, the higher the criminalization of the defendant will be if you can pull them through. All right, because ordinatio militum is like, I don't know, 3 days, depending on what exactly you did. 3 days. Well, if you get example incompetency on top of that, it will be 5 days. You see? So it does make a difference. All right, that's about torts. And I have some more good news. We are done for today. This is where my notes end. I do have the feeling that I did not cover everything. I will give it a thought what I still need to teach you. But this is really the basics. So it was a rather long one, 40 minutes almost. Alright. I hope you're not dead. Okay, I'm going to stop the recording now.